Number 26, the American grand jury right. The American grand jury right was fundamental at the founding of America when the 14th Amendment was ratified July 9th, 1868, and it still serves a useful purpose today. In 2023, the current president of the United States of America was indicted by a grand jury 4 times. The grand jury right is still utilized today. Strict scrutiny requires the government narrows their scope to a strictly defined government interest whenever an American right is circumvented. Strict scrutiny is above intermediate scrutiny and rational basis review. Number 29. James Madison proposed the Bill of Rights without many from Congress commenting on them. We have James Madison's words when he proposed the Bill of Rights. He aimed to codify the great rights of humankind into the Constitution. Natural law is rational man's participation in eternal law. Federal courts use grand juries for felony charges today. You could see the Federal Rule for Criminal Procedure 7A. 3 constitutional provisions. The Grand Jury Clause, the Third Amendment, Ing Blom v. Carey, the Second Circuit 1982, and the Seventh Amendment's Civil Jury Trial Right, Minneapolis and St. Louis, R. Company v. Bombolas 1916, remain unincorporated. No SCOTUS case has addressed these for incorporation. And SCOTUS can't put their seal of approval on a constitutional right until a case is presented to SCOTUS. Ultimately, though, validation isn't needed because our rights in the Bill of Rights are self-executing. 1641 Grand Remonstrance, Section 196, says this, and that judges and justices be very careful to give this in charge to the grand jury and both the sheriff and justices to be sworn to the due execution of the petition of right and other laws. 33, when our government and society doesn't uphold our little civil liberties, then we can return to our big natural Hobbesian enlightenment right to everything. Montesquieu, from the Spirit of the Laws, he says, how iniquitous the laws which, to preserve a purity of morals, overturns nature, the origin, the source of all morality. You Hurtado-loving fools. Madison's desideratum problem, the balance of federalism, is solved by Blackstone's Palladium, the grand jury. Even Hurtado defends a robust preliminary hearing, which is equivalent to an indictment before the case could continue. So you Hurtado-loving fools don't even know what the fuck Hurtado says. Hurtado required at least 6 steps to a robust preliminary hearing for felony accusations. Number 1, an examination and commitment by a magistrate. Number 2, in the presence of the accused. 3, who is entitled to the aid of counsel. Number 4, who has the right of cross-examination of witnesses. Number 5, the witness testimonies were to be reduced to writing. And 6, ultimately a probable cause certificate was issued by the magistrate. Ibid 5:16-17. No preliminary hearing nor grand jury indictment is devoid of all due process. You didn't have a grand jury indictment? You didn't have a preliminary hearing? Then you didn't have any fucking due process, you motherfucking Hurtado crookshank-loving piles of shit. On March 31st, 1871, John Bingham, the great John Bingham, gave a speech solidifying that the 14th Amendment applying to the states is a closed question, absolutely closed, and that the rights protected by the Privileges or Immunities Clause are chiefly defined in the first 8 amendments to the Constitution of the United States. On March 9th, 1866, John Bingham stated that the enforcement of the Bill of Rights is the want of the Republic. John Bingham wanted the federal Bill of Rights enforced everywhere. The 14th Amendment is the enforcement mechanism for the Bill of Rights, presuming the Constitution wasn't self-executing. And last but not least, the slaughterhouse cases. That was a 5-4 split decision. The proposition pending before the House is simply a proposition to arm the Congress of the United States by the consent of the people of the United States with the power to enforce the Bill of Rights as it stands in the Constitution today. It hath that extent, no more. Even if this amendment is ratified, the states will still preserve many of their key powers. The system of federalism will survive, but the Bill of Rights has been a dead letter in the ex-Confederate states. This amendment will address this problem and ensure equal protection for all. Is the Bill of Rights to stand in our Constitution hereafter as in the past 5 years within the 11 states a mere dead letter? John Bingham, 1866, one country, one constitution, one people. The Fifth Amendment, Clause 1 says this: no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Colorado Constitution, Article 2, Section 8 says this: until otherwise provided by law, no person shall, for a felony, be proceeded against criminally otherwise than by indictment, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. In all other cases, offenses shall be proceeded criminally by indictment or information. So some people might say, well, the Fifth Amendment says just capital or infamous. It doesn't say felony, but the Colorado Constitution says for a felony specifically. Madison wrote about how the 6 branches of the dual sovereign governments provided double security for protecting Americans' rights in Federalist 51. First, in a single republic, all the powers surrendered by the people is submitted to the administration of a single government, and the usurpations are guarded against by a division of the government into distinct and separate departments. In the compound Republic of America, the power surrendered by the people is first divided between 2 distinct governments, and then the portion is allotted to each subdivided among the distinct and separate departments. Hence, a double security arises to the rights of the people. The federal grand jury law says that a prosecutor is prohibited from initiating a jury trial without a grand jury indictment or presentment for a capital or otherwise infamous crime. In Colorado's sibling twin grand jury law specifically says that a prosecutor is prohibited from initiating prosecution without a grand jury indictment for a felony. Federal case law has adjudicated that infamous includes felony charges which require a grand jury indictment. See Green v. U.S. 1957 and Mackin v. U.S. 1886. U.S. Constitution, Article 1, Section 3, Clause 7 says, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. Remember that order: indictment, trial, judgment, and punishment. So Congress has the power to impeach and convict U.S. officials, but it only limits that power to removal from office and disqualification from future office. However, that successfully impeached, convicted, and removed U.S. official is still liable for criminal charges. The indictment, trial, judgment, and punishment portion of the impeachment power clause gives us a short overview of what the founders thought of the steps of due process. Their 4-step due process procedure begins with the grand jury indictment, then trial, then judgment, and then punishment. The magistrate power, for magistrate power, see 28 U.S. 636, Article 3. Federal P. Civ R. number 72 and 73. District Court Local Rules 72 and 73. This amendment takes from no state any right that ever pertained to it. No state ever had the right, under the forms of law or otherwise, to deny to any freeman the equal protection of the laws or to abridge the privileges or immunities of any citizen of the Republic, although many of them have assumed and exercised the power, and that without remedy. May 10th, 1866, speech by Representative John A. Bingham. Section 32 of the Magna Carta, 1225, says this: nor will any sheriff or his bailiff make his turn through the 100 save for twice a year, and only in the place that is due and customary, namely once after Easter, and again after Michaelmas. And the view of the Frank Pledge is to be taken at the Michaelmas term without exception in such a way that every man is to have his liberties, which he had or used to have in the time of King Henry